Hi, Mr. Sarhan. What case are you here on, please?
213529.
Right. What are the names? So are you here for Alley Financial in place of McKinnon?
Yes.
Or in, okay.
And also Bank of America versus Maricruz Zarate. I think that's a little bit later.
Oh, yep. Okay.
Maybe 8:45 or not.
Yeah, it is. Thank you. All right. I'm just going to leave you there. If you just want to mute yourself, we're not ready yet. Thank you.
Yes. Yes, you want to do that.
Good morning, Sandy.
Good morning, Heather. I'm trying to help someone get in.
Thank you.
I'm going to come on with my court one in a minute.
All right. Oh, and Judge, in your in basket out here, there's 3 files, I think, that are on today's docket.
Gotcha.
21. Michelle Buckberry's birthday.
Is that why she's gone?
Nope, nope,
Take a
she's here.
birthday day?
Nope, she's here.
Hey, Sandy.
She signed, oh, she's back, sorry. She signed off because she had to come on with a different instrument.
Sandy, are you connected?
Nope, not yet.
Thank you.
Now she is, Judge.
Hey, Sandy.
Yes, Judge.
Good morning.
Good morning.
I've got a file here. Defendant's name is Rhonda Gamble.
Yes.
For an adjournment. She's referring to 2 files. I only see 1 on the docket.
The other file is with Judge Green, and the attorney on that file with Judge Green has, they're sending in a stipulated order to set aside the judgment and dismiss the case.
Okay.
So,
All right. I'll sit on this one to see if she shows up.
all right. Thank you, Judge.
On Benjamin's iPad,
Yes,
what's your name, please?
Benjamin Hill.
Benjamin Hill. Okay, thank you. I'm going to put you back in the waiting room. I just needed to make sure that I had your name.
Yeah,
Thank you.
all right.
And Heather, I assume you have nobody that's ready yet.
We do. I was just waiting on you.
Oh, okay, who you got?
We have the first one, John Telpo versus Delta Airlines. Tim O'Connell.
All right. Bring him in, I'll get my roll.
All right.
Good morning.
Good morning.
Good morning. Judge will be in just 1 minute.
Good morning, Mr. Telepo. Am I saying your name correctly?
Yes, sir, you are. Thank you very much.
Good morning. And for Delta?
Tim O'Connell, appearing for Delta Airlines, Your Honor. Good morning.
Good morning, counsel. And I think we've got defense motion for summary disposition, correct?
That is correct, Your Honor.
All right. Excuse me. And Mr. Telepo, I do not see a written response. So is it safe for me to assume that you did not provide a written response?
I apologize. I do not have a written response. To be quite frank, I'm really not sure what a summary motion is. If I need to retain counsel, I'd be more than happy to do that. There are some things I would like to say regarding that summary that he wrote. So please let me know in the proper time, maybe. I'm
Let
sorry?
me stop you. Let me stop you. Are you asking me to adjourn this matter so you can hire an attorney?
I'm not sure what I need to do. There are some things in here that are said that,
But we're not
My
getting
opi-
into those things. We're
Okay.
not getting into those things until I find out if you want an attorney. If you want an attorney, we'll stop, we'll adjourn it. We'll give you time to get an attorney. If you don't want an attorney, then we're gonna go forward today and then I'll listen to what you've got to tell me. Understood?
yes, sir.
All right, so a motion for summary disposition, motion is just a fancy legal way to say a request. So a motion for summary disposition, in this case, Councilman, if I misstate your argument, please correct me. But in this case, Delta's position is based on the facts that are agreed on and the law that applies to those facts, they're entitled to a dismissal, that there are no important facts that are in dispute. Mr. O'Connell, would you agree with that?
Very well summarized, Your Honor. Thank you.
All right. So if I agree with their arguments today, I dismiss the case. It's over, done deal. If I don't agree with their argument, then we're going to move the case forward. Usually from this point, it ends up with a trial date, although sometimes there are other motions that get filed. You understand where we're at procedurally?
Yes.
All right. Once again, if you want me to adjourn this so you can hire an attorney, I will entertain that request. But I'm not going to spend 10 minutes talking about the case and then have you tell me that we're going to adjourn it. You want to adjourn it for an attorney. Fair enough?
Yes, sir.
What would you like to do?
Let's go forward this morning, please.
Okay. So obviously you've seen the documentation that Mr. O'Connell sent on behalf of Delta, correct?
Yes, I have.
All right. Mr. O'Connell, would you like to hit the high points? I have read it. I looked at it yesterday afternoon. Would you like to hit the high points on that? And then I'll give Mr. Filippo a chance to respond.
Very briefly, Your Honor, I do understand and Delta understands that the court reads the papers. Obviously, I'll entertain any questions the court may have. Otherwise, my comments will be brief. As the court is aware from the motion and supporting evidence, Mr. Filippo had a 2-day baggage delay that was precipitated, at least in part, by his agent removing the subject bag from the airport at DTW and taking it out of Delta's possession, taking it off the airport premises, and taking it to a third-party courier, FedEx, to have it shipped to Salt Lake City. While the bag was en route, and knowing the bag was en route, at great expense, of course, that FedEx bill was over $1,100. While the bag was en route to Salt Lake City, Mr. Filippo went on a $3,600 shopping spree, bought a couple of pairs of ski boots at least, and all the other items are documented in the motion. And then, of course, according to the contract of carriage, Your Honor, which Your Honor is aware of, Delta is not liable for any delay in baggage. That's a matter of federal law, as the airline is entitled to assert such limitations in its contract of carriage. It is not required to deliver that bag in Salt Lake City on the date it was scheduled to arrive. And of course, the contract of carriage also provides that Mr. Filippo is limited to proven damages and losses. And here, Your Honor, we really have not a damage or loss, but a gain, because again, knowing that the contents of the bag, whatever those may be, we still don't know. While the contents of the bag were being sent by Mr. Filippo's agent at the tune of $1,100 to Salt Lake City, he then spent $3,600 buying other items. So as of December 29th, 2 days after he arrived in Salt Lake City, he had the benefit of all of his baggage, as well as $3,600 worth of additional ski boots and other equipment. So what we have here is not a damage or loss, but an actual gain by Mr. Filippo. Nevertheless, he's filed suit against Delta, trying to recover some $5,400 for this 2-day baggage delay. And as set forth in the motion, Your Honor, he's not entitled to that as a matter of law, and as shown in the contract of carriage. And of course, Delta did provide Mr. Filippo with a $1,000 check, which has since been voided by its own terms. But Mr. Filippo decided not to cash that check. And for that reason, Your Honor, Delta is also entitled to summary disposition under MCR 2.116 C7. And Delta would request under C7 as well as C10 that that plaintiff's claims be dismissed with prejudice. And I believe those are the high points, Your Honor. Thank you.
Thank you, Mr. O'Connell. I am unclear on one thing. Well, lots of things, but one thing as it applies to this case. He checked 2 bags at Detroit, and before Delta took possession of both bags, Mr. Filippo took one of the bags and had it shipped to Salt Lake?
Excuse me, Your Honor. My understanding, Your Honor, and based upon the affidavit from Delta, is that the bag, the subject bag, as it's been styled in the motion, was at DTW and it was untagged. Now, it's unclear whether it was untagged by Mr. Chaleppo or by Delta. Either way, it was sort of in a state of limbo at DTW and did not make it on the plane on December 27th. That seems to be an agreed to fact. And what happened after that is that Mr. Chaleppo sent an agent to the airport, we believe it's his father, to retrieve the bag from the airport, which he did. And again, he took it then from Delta's possession, took it off the airport premises, took it to a third-party courier, which is FedEx, and from there spent $1,100 to have the bag shipped by FedEx from somewhere in the area of the airport to Salt Lake City and ultimately to Park City, where Mr. Chaleppo was had his accommodations at the time.
All right.
Does that answer your question, Your Honor?
No, I just raised another one. At any time had Delta taken possession of that bag?
Well, I believe they had it in their possession, Your Honor. But again, because I don't think it was in anybody else's possession. Let's put it that way. I don't think the airport itself had possession of it. Mr. Chaleppo had obviously relinquished possession of it. So my understanding is that it was in Delta's possession at DTW as of December 27th. But again, it was then taken from Delta's possession by Mr. Chaleppo's agent.
All right. So Mr. Chaleppo, let's talk about that bag. What happened that you had somebody take the bag to a third party to ship it out to Salt Lake?
When we arrived at Detroit Airport, we checked all of the bags. We handed each of the bags to the baggage lady. She tagged them. She gave us bag receipts back. At least we thought she tagged them all. In some of those bags, they asked us to walk to the oversized luggage. So we went to the oversized luggage area. We handed the baggage personnel each individual bag. They accepted it. They placed it in the carrier, and we left and went down the terminal. So there are two bags in question, the one that was delayed and the one was lost. So I guess, should I continue or would you have other questions?
Well, you haven't answered, you have not answered my question yet. Do you agree that you had an agent pick up one bag and ship it to you at Salt Lake?
So per Delta's request, we had
Mr.
my
Chaleppo,
father.
Mr.
I'm sorry?
Chaleppo, let's make it easy on the judge. When I ask you a yes or no question, give me a yes or no answer if you can. Did you have somebody pick up one of your bags from DTW and have it shipped by FedEx to your location?
Yes, sir.
Okay, why? I'm confused as to why, if you check that bag, why did it then get shipped by FedEx?
Because they did not tag it and they had no way of even trying to locate that bag. So I'm also a travel agent and I explained that to the people at the airport and along with witnesses. They had told me to try to find somebody to go to Detroit Airport to try to find that bag. So I asked my father if he could. So he went to the airport. He told him the bag was received in Delta's carriage area, and the carriage people had they had to go back into the back room, find it, and give it to my dad. And this was a fairly lengthy process, from what I understand.
Okay, so basically, what happened is you land in Salt Lake, you get all your bags, find out one's missing, make your phone calls, whatever, and find out it's still sitting in Detroit.
Two bags were missing, actually.
Get it and ship it out.
Two bags were missing. One was delayed and the other one needed to be found and shipped, correct. And the reason we shipped it was because Delta, and we've got other witnesses saying that, yes, if you get that, you can ship it and we'll pay for it.
Okay. Mr. O'Connell, anything else?
No, I think the other bases for the motion, Your Honor, are fairly well laid out in the motion itself. So we'll just rest on the briefs unless the court has any other questions.
Okay. All right, Mr. Chaleppo. Thank you, counsel. Mr. Chaleppo, your turn. Go ahead. Your turn to respond.
You know, as a travel agent, they had authorized me. I told them the situation. They understood the COVID situation, the two bags that were delayed. And the person behind the desk in Salt Lake City, where there were other witnesses present, I've got one here if need be. They basically told us to go ahead and purchase other materials as need be and submit the receipts. Also, Delta Airlines had written back, Delta representatives advised plaintiffs to save and submit receipts for any such expenses. They had authorized everything. We had submitted all of the details, receipts. They were received in properly, and Delta came back and they sent a letter indicating they thought $1,000 check would be reasonable. And I believe it's not reasonable. I believe that they made a contract with us, and basically the offer that they said was to go ahead and do these things, submit the expenses properly, which we did. And, they're not living up to their bargain here. I greatly disagree with a couple of things. Mr. O'Connell put some very damning things about myself. I'm an honest person. I have no criminal record. I don't have a traffic record. He put two things in this motion that are absolute lies that I have a major problem with. Additionally, in the recordings I have with Mr. O'Connell, I have other things that he is saying that, specifically about your court, about guarantees, that I completely disagree with. You're an honorable judge, and I don't think some of these things are proper. I think I keep getting led down the wrong road here, Your Honor. I mean, we did everything we were supposed to do by the letter. I've got all the documents here. Delta's values right here, integrity, always keep your deals. This is Delta Airlines, always keep your deals. They made a deal with me. And, this is not only this is a personal situation. I had two kids involved and a wife, which is not a matter of law. It's a matter of a situation where we were put in a really bad situation by Delta. Delta recognized it. And as a travel agent, she came back and told me what to do. And I told my family what to do. So we did exactly what they told us to do. And, we believed them. Now we're getting the short end of the stick. Not only by that, but we're getting Mr. O'Connell, in my opinion, is making false statements. And I completely disagree with it. I have no problem sharing with, anything I do have here. I would like this to go forward. I think that, we've submitted everything exactly to what they said. And, Mr. O'Connell's even made additional offers to me, above and beyond that $1,000 to accept this and take it to the next level, to decrease Delta's costs in this situation. They're just trying to get this cost down, and, it's understandable, but they put me in a really bad situation. They made an offer, we accepted it, and we went out and bought the stuff. And it's just not right.
So 2 or 3 times now you've said that there are things in Mr. O'Connell's motion that he filed that are not factually correct. What are those things that you disagree with the facts?
So he says plaintiff never provided receipts. We absolutely provided receipts. He wrote in here, plaintiff represented to undersigned counsel that plaintiff himself could not recall the contents of the subject bag. In the recording I have, he redacted that sentence, in my opinion.
All right, so if you've read his paperwork, and I'm sure you have, it talks about the fact that Delta's liability is limited to proven loss or damage. You agree with that?
I saw that.
That's not what I asked. Do you agree that that's what their liability is? It's limited to proven loss or damage. Do you agree with that or not?
Yes, I do.
Okay, so what are your losses or damages?
So the losses that I had based on the contract I had with them were the receipts that I had submitted. And to be quite frank, probably more than that, because we had ski passes, we had other issues. But, basically I'm going forward with what Delta told me to submit.
Which did not answer my question. Give me one thing that you're out now that you had before you went to Detroit Airport.
Roughly $5,400.
Okay, but why? Why did you buy all new things when you knew your stuff was on its way?
We didn't know it was on the way. Delta Airline told us specifically the bag that was lost, the bag that was untagged, she specifically told me we may never find that bag because it was untagged. That's why they told us to go ahead and purchase other things. They said it's an untagged bag they received. They said they have absolutely no idea if they can find it. And here I said, basically, I'm on a ski trip with my family. What do I do? And they told me exactly what to do. And I followed that to the letter.
So you purchased $5,000 worth of new merchandise before you realized that your father had possession of the bag and was shipping it to you?
To the best of my recollection, yes. But in that is also there was other things in that bag. So hold on one second. Let me see if I can. I don't know the timing, but I can definitely find that out for you, Your Honor.
Anything else, Mr. Filippo?
We submitted all the expenses that we were supposed to submit, and I'm out greatly on this. And frankly, it's they had made a contract with me, in my opinion, and they are not living up to their terms in their contract. They said they have received everything properly. They even sent a check trying to get me to accept short payment on it. They know they were wrong. And additionally, they asked Mr. O'Connell to offer me more money, another $1,000. They offered me another $1,000 for $2,000 total. So basically, they're just trying to get me to go away. And
well, that's part of the process. That doesn't mean there's anything nefarious. That's just any business trying to cut their losses. So did you catch Mr. Taleppo's argument in his brief? I just lost my train of thought now.
And, if I may, here's another email from Delta. Full copy of receipts for any reasonable items purchased while your luggage was delayed and the list of items purchased. I submitted everything to the letter to them and they accepted it.
Okay. Mr. O'Connell referenced in his brief the fact that the contract between the passengers can't be changed by people at the gate. I'm paraphrasing. Did you read that?
Yes.
Okay. You disagree?
I completely disagree. She was not at the gate. She was in the baggage terminal. Additionally, she made several phone calls that I'm not aware of. So in my opinion, she had authorization from the proper people to make that. And additionally, as I mentioned, I am a travel agent. So I'm assuming that she made the proper phone calls and got the proper authorizations to do what she needed to do to make it right.
Anything else, Mr. Taleppo?
Not to my knowledge. I'm sorry, Your Honor.
Okay. Mr. O'Connell, response?
Well, I think that in terms of the timeline, Your Honor, I think that was clearly laid out in the affidavit and the motion. There's no question that the FedEx receipt shows a scheduled delivery of the 29th. So the bag was shipped before then, as detailed in the motion. So in fact, when the spending spree happened, in fact, Mr. Taleppo knew that the bag was en route. There's no evidence to the contrary. As Your Honor pointed out, well, first of all, there's no evidence that Mr. Taleppo was ever authorized to spend $3,600 on brand new ski equipment for a 2-day baggage delay, assuming the baggage that was delayed even contained ski equipment, which has never been established by any evidence whatsoever. And even so, the evidence provided by Delta shows that the conversation that Mr. Taleppo had with Delta was on December 29th, 2 days after the baggage delay, after the bag had likely already been delivered or was definitely en route from FedEx. And the agent told Mr. Taleppo that he was entitled to, that there was generally a $50 per day for the first 5 days, reasonable amount for a baggage delay, $50 per day, not $1,800 per day, which is what Mr. Taleppo spent. And they also told Mr. Taleppo that he was entitled to provide receipts for rentals. Mr. Taleppo did not rent. It appears that Mr. Taleppo did not even think to rent. The receipts referenced early on in Mr. Taleppo's argument were receipts for rentals. He never provided any rental receipts whatsoever. Instead of renting, Mr. Taleppo essentially took this as carte blanche to buy brand new ski equipment for equipment that was knowingly en route to his destination. That is completely unreasonable. And again, Delta did provide him with $1,000 check, which, as you pointed out, is not nefarious. That was the reasonable amount, according to Delta, that Mr. Tleppo could have gotten by with during those 2 days. And in fact, that seems like quite a lot. It's 10 times the $50 amount that's sort of the baseline for these types of things, Your Honor. So I'll leave my comments there and again defer to the briefs and the evidence, including the affidavit from Delta in support of the motion. And again, Delta asked for dismissal with prejudice of Mr. Tleppo's claims.
Thank you. Mr. Tleppo, anything else?
The $50 a day, I'm trying to find what Mr. O'Connell had said, but he, in my recollection, he made it very clear that that is not a cap. And I have further evidence of that from Delta in email. So from Saturday, January 23rd, from Delta Airlines, the guidelines for reasonable expenses are not a daily cap. The guidelines for reasonable expenses are not a daily cap. And that is from Delta Airlines, January 23rd, 2:19 p.m.
All right, anything else?
That's the claims manager. I don't think so, Your Honor.
All right, thank you. Mr. Tleppo, I'm going to grant the motion that Delta's filed. This case is dismissed. I don't think it's reasonable, even if you didn't know for 2 days whether or not your dad had located the bag. It's not reasonable to buy $5,000 worth of equipment when you can rent it for a couple of days to see if your bag's been located.
Due to COVID, which I made it very clear with kids at the with the claims agent, you know, that is what their suggestion was. So basically, Your Honor, we did everything that Delta Airlines told us to do. And, you know, they understood the concerns. And as an agent, they told me what to do, and we told our family what to do. And basically, from what I'm hearing you say, is that the contract we had at that point in time with Delta is absolutely no good. They made an offer, there was an acceptance, and there was consideration, and it's absolutely no good. Am I hearing you correct?
What you're hearing is the contract you enter into when you buy the ticket can't be changed by the people on the ground. And you keep referring to the fact that you're a travel agent, then you should have had something in writing. I think it's an unreasonable claim that you're making. I've granted the motion. Your case is dismissed. You are free to appeal me to the circuit court. Goodbye.
Understandable.
Heather,
Thank you,
what's
Your Honor.
next?
Next, Judge, Mr. Alexander Sarzen is here for, we're going to do Alley Financial versus Eva Sims. Grant Munso is here for Eva Sims.
Thank you. Gentlemen, your appearances, please.
Alexander Sarhan, P77252 on behalf of Ally.
Good morning, Grant Munson, P71994 for the defendant.
What do we have today, fellas?
This is regarding Allies, an amount owed to Ally regarding regarding a vehicle that was repossessed back in 2018 and the amount owed.
All right, so I had the parties in back in October. We adjourned this for discovery. Where are we at now? We going to trial? We going to motions? Where are we at?
No motions for defendant. I anticipate plaintiff will probably have one.
Counsel?
Yes, Your Honor, we will likely file a motion for summary disposition.
All right, let's talk time frame. You want me to just give you a motion date now and you can back into it with your filings?
Yeah,
Yes,
I think that'd be great. If we could have a motion date, maybe 60 days out or something like that, we can work from that.
Sandy, Heather, help me out with the date.
2:15 at 9 a.m.
That works
February
for me.
15, gentlemen.
Yes,
Thank you.
Anything else we can do today?
Nothing from defense.
nothing
great
from
day.
plaintiff. Thank you.
Merry Christmas. Heather, what's next?
You too, Your Honor. Thank you.
Next is Discover Bank versus Fletcher.
Thank you.
Yeah.
Morning, Judge. It's Sandy. I sent up a consent judgment. Is that one coming off of the record? Second round versus Ivy Frazier? They are calling.
Let me see if that's one I signed. Yeah, I signed that one.
Okay, thank you.
You're welcome. Counsel for Discover Bank, your appearance, please.
Yes, good morning. Attorney Jason Brainer.
Looks like Mr. Fletcher's not yet connected.
Okay.
Mr. Fletcher, you there?
He's trying. He's connected, Judge.
Mr. Fletcher, good morning. You're muted.
Okay, I got it.
All right,
Can you
Mr.
hear?
Fletcher, I've got, yes, I can. I've got Attorney Brainer on the Zoom meeting representing Discover Bank. Counsel, where are we at? Do we need discovery for Discover Bank?
No, so Your Honor, we actually reached an agreement about 5 days ago, and we are in the process of drafting the consent judgment to send over to defendant. So if we could just adjourn for, say, 45 days, that should give us time to sign it, send it back to the court, have it entered, and then we should be on our way.
All right, what I'm gonna do is I'll just put it on the no progress docket for at least 45 days down the road. That makes sense, Counselor?
Yep, that makes sense.
All right, Mr. Fletcher, agreed? You made your agreement. You just got to put it on paper and get it to the court?
That was my understanding too, Judge.
Awesome. All right. Have a great day.
Have a good one.
Thank you, Your Honor. Happy holidays.
Thank you.
Next
You
is
too.
Barber versus Menards.
Thank you.
Yep.
Gentlemen, your appearances on Barber versus Menards, please.
John Day appearing on behalf of the plaintiff, Mr. Barber.
Gary Ream appearing on behalf of defendant Menard Incorporated.
Good morning, gentlemen.
Good morning.
Morning, Mar.
Looks like we had a pretrial back in September. We adjourned it probably for discovery.
Yeah, we did, Your Honor. We attempted. I made an offer and it has not been responded to at this point. So I'm really not sure where we are.
Mr. Rowe?
Your Honor, yeah, I apologize if I did not respond to Mr. Day, but my client was not acceptable of the offer. So I suppose that would have been the response anyway.
Okay. You need a trial date then?
Yes, Your Honor.
That's fine, Your Honor.
What's this going to take to try, gentlemen? An hour?
Not much more than that.
Agreed.
Okay. Hey, Sandy, we got a date
Yes,
before
Judge.
February 5th?
We can do January 25th. I'm sorry,
Really?
January 18th. January 18th is the only date I have.
How's that look, gentlemen? Later in the morning, let's say 10 o'clock?
All right, Your Honor.
Mr. Rome?
Sorry, Your Honor. I was just looking real quick here. Is that in person or via Zoom?
I like to see people. I don't see them anymore. but
Okay,
if
that's
there's
fine.
any good reason to talk me out of it, you can try.
No, what time was it going to be at?
10 a.m. We're agreed then, Mr. Day, this will be live?
Yes, Your Honor.
Yes,
All right.
I should be able to make there in time. So
Good. That's always easier on the staff when we're shuffling paperwork. All right, gentlemen, anything else?
That's it, Your Honor. Although I have
Be
another matter
productive
with you.
today. You do?
Yep,
Then hang around till we're ready for you. Mr. Rowe.
I will do
Merry
that.
Christmas.
Thank you.
Okay.
Merry Christmas.
Thank you, Your Honor. Thank you, Mr. Day. Merry Christmas.
Mr. Day, what is the other case that you have?
Hill versus Summers.
Sorry, what was the first name you said?
Hill, Hill,
Thank you.
Benjamin Hill.
So you're here for Miss Summers?
Yes.
Okay, I don't see you on there.
Looks like Hill's here.
He is. I will bring him, or are we gonna do,
Bring him in. Bring him in.
all
Mr.
right.
Day, have you filed an appearance for Summers? Because we don't have it on the file yet.
I filed an appearance and I filed a motion for summary, Your Honor.
Oh, you know what? I did see the motion. We just don't have you listed on the ROA. Okay. Morning, Carrie.
Morning, Judge. How are you?
Better than I deserve. Mr. Hill, can you hear me?
Yes.
Do you have
Trying to
video?
turn this thing on. How we doing? Good morning.
Mr. Hill, do you have a video?
Yeah. Yes, sir. Can you hear me?
I can hear you, but I can't see you.
All right, let me tap here. How about now?
No.
Okay. Here. This here.
No video. Let's see if we can do it without it. Did you get a copy of Mr. Day's summary disposition motion that he filed on behalf of Ms. Summers?
Yes, we received that. Yes, we received that on the. Let's see. 12/17.
Probably back in
Due to the fact
November.
Mr. Day had the wrong address on the paperwork. It was sent to a neighbor's house. He had address
You
on
did
that
get it.
paperwork as 24685. On his Huron River Drive, he put the wrong address on.
Okay, but you did receive it, correct?
Yes, we ended up receiving it the other day.
Okay. I'm looking at the court file. It looks like you did not file a written response. Is that also correct?
A written response, meaning we filed with the court and on we served Ms. Summers on the 10th. We filed a response.
No. My question is, you got a copy of the motion that Mr. Day filed with the court. You did not respond to that motion in writing, correct?
Correct.
Okay, so I don't have to look for some documentation that I don't have. Would you like to respond to that motion orally today?
On this motion, yes, that's what we're here for, correct?
Correct.
His motion.
Basically what he's
Okay,
saying
go
is
ahead.
because you're not a licensed contractor, you can't use the courts to collect money.
I am a
Mr. Day,
licensed
is that a fair
contractor
summary?
through the state of Michigan. That's
Hold
a
on a
false
minute, Mr. Hill.
allegation.
Mr. Hill, my turn. Mr. Day, is that a fair summary of your position?
Yes, Your Honor, that's a fair summary of my position. He's not filed a proper complaint pleading the facts required.
All right, Mr. Hill, your turn.
I object against that. I filed a complaint in the ideal that I was not paid for standing work done on the restoration portion of this job. I am a licensed contractor through the state of Michigan and business also insured. I was approved through State Farm to do said work. That's how this job got started. And this is how this job got approved. This job would never been approved through State Farm if I was not licensed and I did not send in my paperwork to them.
We did a check through the state of Michigan. We could not file a license for Mr. Hill.
If I could pull this up, I do.
What's the,
I know how to get
Mr.
this.
Hill, is a license in your name or some kind of a business name? What's the name on the license?
License is under Benjamin Hill. License number, would you like the number, sir? I can't get the video. I got the license right in front of me. If I could get my video to pull it, be able to show it to you, but I can give you the license number. License number is 242-000-120. Expiration date is 5/31/2023.
Mr. Day, that would seem to create a material fact in dispute.
That would seem to do that, Your Honor.
All right. So I can set this case for trial if you're ready to go that route. I can
That would be fine, Your
suggest
Honor.
maybe mediation if you think that would help.
Possibly, Your Honor. I've never been opposed to mediation.
Mr. Hill,
Yes.
understand what I'm saying?
Mr. Day, I did get your paperwork, if you don't mind me talking directly to you. I did get your paperwork on the late, the address was wrong. I came to your office yesterday and dropped off everything I had for paperwork on this case. And everything, dates, times and everything, because I seen you guys' dates and times. You obviously didn't have none of that information. So I wanted to make sure you had everything that I had and what my standing was on this. So there wasn't no miscommunication and you had everything you needed.
Mr. Hill, I was out of my office all day yesterday in depositions, and I did not receive your whatever information you dropped off.
Yes,
Did you leave it with somebody?
I left it with a lady. Your office was closed. I knocked on your door and I left it with the lady there. I did not obtain her name. But
Okay.
and if you don't receive it, I do have your address.
I'm gonna make this
By any
suggestion,
means, you have my
gentlemen.
phone number, everything's there, so I
Okay,
can bring another
Mr.
copy
Hill.
there if needed.
Mr. Hill,
Yeah,
I've got a full docket today, so if you guys want to talk, I'll put you in a breakout room. But my suggestion is we just adjourn this pre-trial, give you two a chance to talk with the idea if that doesn't resolve the case, I'll send you to mediation. Agreed?
agreed.
That'd be fine, Your Honor.
All right. When's our next date, Heather?
We can do 118, Judge.
How about 118 at 9 a.m., gentlemen?
I have no
Fine, Your Honor.
objection to that at this time.
I'm sorry, Mr. Hill?
I have no objection against that at this time.
Okay. All right. Merry Christmas, fellas. Good luck.
Thank
All
you
right,
very
take
much, Your
care.
Honor.
You're welcome very much. Heather, what's next?
Next is TC October versus Tiffany Anderson.
Good morning, Your Honor. Carrie Zanin, P67390 on behalf of plaintiff.
Ms. Anderson, you are muted.
Good morning.
Good morning. So my notes show that we met back in November on the 23rd, and that you had reapplied for Sarah. So where are we at with Sarah, Ms. Anderson?
I called them yesterday and they said that they're waiting for a caseworker to take my case. I have also talked to the other agency that I was going through. I talked to them December 6th. They told me that I needed the landlord to fill out their behalf and send it back. And so I talked to my landlord. He said he sent it back. So that agency said it takes about approximately 30 days for them to review his part that he had did, because everything on my part was done. So he filled that out. So we're just waiting to hear back from them or the Sierra first.
And Judge, at this point, I'm asking for a judgment. This case has been going on for probably 6 months at the least amount. I'd be willing to do a judgment with a 30-day window just to have it in place because we have been waiting so long. There is a $7,000 balance due on rent at this point, Judge.
Looks like it was filed May 25th.
And Judge, if Sarah funds come through, I have no problem then dismissing the case. But at this point, my client is asking to proceed to judgment. Granted, it's a
Understood.
possession judgment.
Thank you. Ms. Anderson, any response?
I didn't know about that because Lance talked to me yesterday and Lance is on his way to my house right now. And he said, as long as that the programs are willing to help, they're willing to allow me to stay.
And I'm not saying that I'm not, but I'm trying to get a judgment in place. I would do a 30-day written issue date, but I would like to have a judgment in place at this point. And like I
Ms.
said,
Anderson, I'm sorry, counsel.
I'm sorry,
Ms.
Judge.
Anderson, what counsel's asking for is a judgment that they can't do anything with the judgment for 30 days. So in essence, they cannot evict you within that 30-day period. That'll give you 30 days to get something from one of the agencies so you get some money to the landlord and resolve this. Understood?
Okay.
And counsel, will you submit that? You're gonna do it by electronically so we can sign it today? What's your pleasure?
Yes, yes, I'll do, I will draft it now and email it over. Yes.
Okay. Ms. Anderson, I've known this attorney for years. She's a very reasonable person. So if you get any documentation from the agencies, just make sure you're sharing your information with her.
Okay.
All right. Good luck to you, ma'am.
Thank you, Judge. Have a nice holiday, everybody.
You as well.
You too, thank you.
Heather, what's next?
I'm gonna guess Daniel Holzman is here for Charles.
That would be
Thank you. So we're doing Michigan versus Rannenbarger.
Got it. Counsel, your appearance for Michigan Legacy Credit.
good morning, Your Honor. Daniel Holzman, PA 2344, on behalf of the plaintiff.
In Madison, I'm going to pronounce it Raineberger. How do you say it? Madison, are you connected? Says she is.
I'm wondering if she doesn't have very good service, because I spoke to her in a breakout room a few minutes ago.
Your Honor, would it be possible to place the defendant and I in a breakout room so that maybe hopefully I can assist her in getting her video connected and possibly
That
resolving?
would be great. That would be awesome. Thank you.
Thank you, Your
Let's try
Honor.
it.
Yep, doing it right now. Next, Judge, I will bring in First National versus Westmoreland.
What other file is Mr. Saran on?
He is on Maricuse Zarati that has not appeared yet.
Thank you.
Start video. There we go. Good morning.
Counsel, your appearance for First National Bank of Omaha versus Westmoreland.
Good morning, Your Honor. Najat Francis on behalf of Plaintiff's Attorney of Record.
Good morning, Ms. Francis. Ms. Westmoreland, my file says you got an attorney, Malakote.
No, I don't have anybody representing me.
All right, no attorney today?
No.
Thank you. All right, Ms. Francis, this is defendant's objections to garnishment, correct?
I'm sorry, Judge. Yes, this is
Miss-
objection to a wage garnishment.
Okay, and Ms. Westmoreland, I'm looking at the documentation you filed on December 3rd, I think, December 1st. And it says the reason you are objecting is because you were never served and you were not aware of a court date, correct?
That is correct.
All right, anything else?
Besides the fact that I was not aware of it due to the fact of I was not served, and the dates that they say that they served me don't even match up because I had just had a baby a month before that. So I wasn't even within the area to even be served. The amount that they were asking for in the first place is just too much for me to afford while trying to take care of my 4 children and put a roof over my kid's head. My husband's disabled. He only gets SSI. So basically, we're just living off of my income.
Ms. Francis, any response?
Judge, defendant is attacking the underlying judgment, which is not allowed through an objection to garnishment. So I would ask for her objections to be denied at this time.
Westmoreland, you understand that? Objections to
No.
garnishment are what basically you're not really objecting to the garnishment, you're objecting to the underlying lawsuit because you didn't know about the judgment.
Okay,
So-
well, to be honest with you, I've never went through this before, and
That's a good
I
thing.
guess I should have gotten a lawyer. I just found out I have COVID, and I'm
Yep.
trying to heal up from that, so I just really hadn't had time to do all that.
All right, well, good luck with that. What I'm gonna suggest you do is you wanna file a motion to set aside the default judgment. If you weren't properly served, and if I understand your argument, that's
Yeah,
your
I was never
position.
served papers. I was never served
Okay.
papers and aware of a court date in order to go and to discuss the situation.
All right. Then if you want to attack the judgment, that's what you've got to file. All you've done is you've addressed the garnishment itself. You haven't addressed the underlying judgment that led to the garnishment. Understood?
Okay.
All right, so you need to file those papers. This is a wage garn, Ms. Francis?
It is, Your Honor.
All right. Sandy, I'm sorry, I wasn't smart enough to write down that court date you gave me when we adjourned that pretrial. Was that January 18?
Yes, Judge, it's January 18th.
Thank you. All right, Ms. Francis, you know I don't do this generally, but I'm gonna do it today. Ms. Westmoreland, I'm gonna
Yes.
adjourn this till January 18th. I'm gonna give
Okay.
you some breathing room till January 18th. What I would suggest you do is contact Ms. Francis, because if I hear you correctly, you're not denying that you owe some money. You just
Correct.
can't pay what you owe, what they say you owe. So she's a reasonable lady. Contact her instead of filing a bunch of paperwork, because I'll be honest with you right now. If you file a motion for someone to set aside the default judgment, there's two questions I look at. Is there a good reason that you didn't answer the lawsuit? And in your case, your argument is, I didn't know about it, which is a pretty good reason. But the second question is, do you have an underlying defense to the claim? And you really don't. Your defense to the claim is, I don't have the money. So even if you file that, I'm probably going to deny it, and it leads you right back to where you're at right now.
Right.
So what I'm going to suggest you do is talk to counsel, see if you can set up some kind of voluntary payment arrangement, which will free up your wages, so you don't have to worry about your wages being garnished. And if it's a set amount every week or 2 weeks or month, whatever, then you can kind of budget for that and try to get them off your back.
Okay, and that's what I would appreciate, because I do know that it is my debt, and I never was doubting that, at all, because it is mine. But it was, I just
appreciate
didn't.
that.
Yeah, I was not aware of the situation as far as being served or anything like that, and just having a baby at that time, and then getting hit with the wage garnishment, especially right now, it was all a lot at one time. So it's like,
Right.
I want to pay it
I
back
hear ya.
because it is my debt.
I hear you, and I appreciate that. But here's what I'm doing. Basically, she won today, but I'm not going to let her win today because I want to give you some time to work something out so it's not wage garnishment after, week after week after week, to get
Okay.
something resolved, hopefully that you can live with. So I've adjourned it till January 18th. Once again, I know her. She's easy to deal with. She's going to do whatever she can to work this out based on whatever leeway she's got from her client. All right?
Okay.
What
Worst
time,
case
Judge?
scenario is, go ahead, Ms. Francis,
Sorry, Judge. I didn't hear a time for the 18th.
9 a.m.
Oh.
Right. So if you ladies work something out, Ms. Francis will let me know, and you won't even have to come back to court on January 18th.
Okay.
If you want
You
to
can
put
withdraw your objections. Ms. Francis, go ahead.
If you want to put us in a breakout room, we could discuss it now, Judge.
Awesome.
I would
Sure.
appreciate that.
Sure, absolutely. Heather will put you ladies in a breakout, and I wish you luck.
Yep, doing it now. Can you ask Mr. Best if he is done with Miss Adair?
Yes.
I
Mr.
tried.
Best.
Yes, we are. And it's actually Mr.
Okay.
And he's back in the main courtroom as well. We're ready to
Okay.
go before the judge.
Sorry, I couldn't figure out this phone.
Counsel, your appearance for Capital One, we've got Mr. Dare on Zoom.
Thank you. Good morning, Your Honor. Daniel Best, P58501, on behalf of plaintiff Capital One Bank.
And good morning, Mr. Adair. Counsel, what do we have?
Your Honor, we have a motion for summary disposition up for this morning. I've spoken with Mr. Adair. We have not resolved it. He is working with a debt settlement company. The debt settlement company has not been in touch with my firm. I did provide him a couple of offers to take back to them. I did explain to him that having a debt settlement company is not a defense to the debt. Even though I do have the offers outstanding, we would still prefer to proceed with the motion. Those offers are good for 14 days, regardless of whether a judgment gets entered or not.
Thank you. And Mr. Adair, did you get a copy of the motion for summary disposition that plaintiff filed with the court? Looks like it was filed way back in October. Did you see that document?
Yes.
Okay. I don't see a written response from you in the court file, so I assume that means you didn't file anything.
No.
Okay. All right. Mr. Best, I'm going to ask you to hit your high points. I did review the motion earlier, but I'm going to ask you to hit your high points, and then I'll give Mr. Adair a chance to respond.
Very good. Thank you, Your Honor. Again, this is a collection action on a credit card account. We support our motion with a litany of statements, a number of payments that were made on the account agreement, and the affidavit of our client substantiating both the account and the account balance. We're requesting that the court enter a judgment for a total of $3,932.68, representing damages of $3,774.88, cost of $157.80. Your Honor, we're specifically disclaiming interest and have the rate of interest in our proposed judgment being at 0%. Judgment interest, we're disclaiming, I'm sorry.
Mr. Adair, I should have started with this, and I apologize. But usually in these situations, I explain to you exactly what a motion for summary disposition is. Motion is just a fancy legal word to say request. So Capital One is requesting that I grant their request for a judgment. And their argument is that there are no substantial facts in dispute. And based on the law that applies to the facts in this case, they're entitled to a judgment. So if I agree with Mr. Best's argument today, case is over, I enter a judgment. If I disagree, if I deny his motion, at that point, we're going to put the case back on the calendar, probably set a trial date. There might be some other motion that Mr. Best has in mind, but usually from this point, it's a trial date. Do you understand procedurally where we're at?
Yes.
Okay, so this is your chance to respond to their motion.
Yeah, I'm willing to pay whatever needs to be paid. It's just when this went down, my family had really got hit with COVID, and I had gotten laid off of my job for over a year. I had to shut down a personal business I owned. And then my wife got COVID and she had to be out of work. So it was either I buy food for my kids or pay a credit card bill. And that's why I said no, this
all right.
consolidation.
So basically what I just heard is you owe the money. You just need to work something out.
Yeah.
Okay. So I'm going to grant his motion for summary disposition. Nothing's going to happen for at least 14 days to give you a chance to talk to your debt consolidation advisor about the offers that are on the table. Do you understand that?
Yes.
Do you have any questions?
No.
All right. I wish you luck, sir. Mr. Best, you'll submit some paperwork.
Yeah, I was going to say, we did provide a proposed order, but I'd ask the court not to sign that. Let me submit it under 7-day just to give us a little more time.
Actually, you know what? Probably drive Sandy nuts, but I'm just going to sign it and date it 2 weeks down the road.
I have no objection to that. Mr. Adair, any objection?
No.
Thank you, Your Honor.
Thank you.
Thank you, gentlemen. Good luck, Mr. Adair.
Thank you.
Everyone have a good day and a happy holiday.
You as well, sir.
Mr. Holzman, do I need to bring back Madison?
If she hasn't found her way back, yes, please.
Okay, I'll move her in.
Thank you.
Sandy, I just made a note in that file. We'll just sit on that order until 14 days is up before we mail it out. What one next, Heather?
It's going to be Michigan Legacy versus Renenberger.
Okay. Madison, how do you say your last name?
Ranenberger.
Oh, Heather got it just spot on. Good morning. Mr. Holtzman, your appearance.
Good morning again, Your Honor. Daniel Holzman, P82344 on behalf of the plaintiff.
And where are we at?
Your Honor, the defendant and I had an opportunity to speak in the breakout room, and we've reached a resolution for this matter. I informed her that after this hearing, I'll be emailing her a proposed consent judgment for her review. And assuming that she's agreeable to those terms as written, we will be submitting an order to the court.
Ms. Ranenberger, correct?
She's on mute. I think her child is making noise.
Yeah,
Is
that's
that
correct. Yes.
Okay. Oh, she's precious. All right, so what I just made a note in the file that consent judgment was reached, paperwork to follow. We'll just put it on a no progress docket. 30 days out gives you plenty of time, Counselor.
That is my hope, Your Honor. Is it
All
possible
right.
we fax the consent judgment once it's signed?
You can email it.
Perfect.
Yeah, you can email it.
All right, as long as I don't have to rely on
questions?
snail mail, 30 days should be plenty.
Okay. Ms. Brandenburger, any questions?
No.
Merry Christmas.
Merry Christmas.
Thank you, Counsel.
Thank you, Your Honor. Have a happy holiday.
You as well. Heather?
Sweets versus Stevens.
Okay, Mr. Sweet, can you hear me? I got video. You got audio?
Yep, I can hear you.
All right, Mr. Stevens, you there?
Yes, sir. Good morning, Your Honor.
Good morning. Do you have video?
Yes, I do.
Can you connect?
I should be connected, Your Honor. I see you quite well.
I don't see you at all.
Oh, geez. Let's see. There you go.
Yeah, you got it. Miss Westmoreland, did we forget something?
Oh, maybe I went to the wrong thing. She told me to go back to the courtroom.
Heather?
I know we decided to stop the objection and we made a plan.
Yeah, we adjourned this to January 18th, so you're all set.
Okay, thank you.
Good luck. All right, gentlemen, bear with me just a minute. Mr. Sarhan, what time was that last file of yours scheduled?
I believe
8:45, Judge.
Was that Bank of America versus Zarate?
that's correct.
Not that I don't like seeing you on my Zoom screen, Counsel, but let's get you out of here so you can go out and make some money today.
Sounds great.
Trying to figure out what was scheduled for today. Is this a pre-trial?
It's a pre-trial. Yes.
All right, and I still don't see, anybody that's unidentified or looks like Mr. Zarate. So Counsel, why don't you submit a default judgment under a 7-day rule?
I'm in court, shut up.
We'll give him a chance to tell us why he didn't show up.
Okay, great, Your Honor.
Have a good day.
You as well.
All right, Mr. Sweets, Mr. Stevens, today's the date and time set for a small claims hearing. Let's get some of the ground rules out of the way. If we go forward today with a hearing, when I make my decision, you're stuck with that decision. You cannot appeal it to a higher court. Mr. Stevens, Mr. Sweets, you understand that?
Yes, sir, Your Honor.
Yes.
All right, if you want the ability to appeal my decision, then we have to remove this case from the small claims division into the general civil division. Understood?
Yes, sir, Your Honor.
All right. Fellows, I can guarantee you while you're speaking today, I am going to interrupt you because you're going to say something. It's going to trigger a question in my mind. And the way I work best is I ask the question so I can start processing the answer. I don't interrupt you because I'm trying to throw you off your game plan. And I know it's rude. That's why I apologize in advance. It's just the way my mind processes information as it's coming in. So let's see what else. I'm assuming I'm going to hear from both of you. Are there any witnesses that either one of you are going to call?
No.
No,
Mr.
sir, Your
Stevens?
Honor.
All right, so both of you fellows raise your right hands. Gentlemen, do you swear or affirm, tell the truth, the whole truth, nothing but the truth today?
Yes.
Yes, I do.
Okay, the other, you put your hands down. Last thing is, let's take turns. So if Mr. Sweet's talking, Mr. Stevens, don't interrupt him. Mr. Stevens is talking, Mr. Sweets, don't interrupt him. I'm gonna give you a chance to go back and forth. Before you're done, I'm gonna ask you at least 2 or 3 times, anything else, anything else, anything else. When you both tell me no, at that point, I'm gonna make a decision. Understood?
Sure.
All right, Mr. Sweets, you started this action. This is your chance to convince me that Mr. Stevens owes you money and how much money he owes you.
Yep. Yeah, I hired him to do my driveway, and he barely did any work. He just scraped my driveway, and then he cut out a little parking spot, and that was it. That was it for $2,000. And then, yeah, that's why I took him to court. I want my money back. He didn't finish the job, and he was I don't know the correct terminology, but he's just he's not with it. He's not all there. A little bit crazy, I guess you could say. Yeah, he just went crazy and took my money. Scam artist. That's all I got to say. And I want my money back, and I want everything I stated on the paper that I wrote to you. Pretty simple.
All right, so was there a written contract between the parties, Mr. Sweets?
Yep. Yes, there was. You should have it.
All right, Mr. Stevens, I've got something in the court file. It looks like it's dated June 29, 21. Says Stevens up at the top. Affordable Cement Designs. Proposal submitted to Matt Sweets. Are you familiar with that? And is that the contract that's in play here?
Yes, sir. I make a contract with every job I do.
Okay. All right, so let's see what we got. Grade areas agreed, approximately 1,200 square feet. Lay 2 inches, commercial grade hot asphalt, compact, vibratory, 90%. Density, I think. Is that what that says?
Yes, sir. Density.
Okay. Guaranteed for 2 years, no maintenance required. Total would be $4,600. 1/2 deposit required upon start, balance as needed. Finish date, Wednesday or Thursday, weather permitting. And deposit was $2 grand, is that right?
Yes, sir.
Yep.
Okay. All right, so Mr. Sweets, you filed an affidavit. So did you pay the full job?
I paid him $2,000. And like I said, he worked for like 2 hours and barely did anything. And then he just pretty much scammed me. He just started saying all kinds of false accusations. And then that was it. He took my money.
Okay, but you sued for $5,000.
Correct. I want my money back plus the damages and everything else. He damaged my concrete with his excavator. Oh, then, all the court fees and my time. Yes, 5,000. Correct.
Okay, what concrete? Because I don't see anything in the contract about concrete.
I got a picture of it on my phone.
Okay.
I don't know if I
This
can.
is your chance, this is your chance to tell me what he owes you.
Yeah,
I shouldn't have to ask you questions what your 5,000 means. This is
I just
your
told.
chance to.
Yeah,
you
it was
told
all
me.
written. It was just written. It was written down. It was written down. I thought it was, I thought I had it itemized. Like I said, the 2,000 that I paid, I want back. And then for my time, and then the concrete, pretty much. So it adds up to 5,000. The concrete was like 1,500, 2,000 my money back, so that's 3,500. Or then 1,500 for my time. So that adds up to
Your time
5,000.
doing what?
This. My time dealing
Brother,
with.
I don't get paid $1,500 to do this. Why should you?
Just that's just the number I came up with. I'm not. This is new to me. I've never sued anybody. It's the first time. I just know that I got scammed. So
You paid $1,500 to repair some concrete?
no, I did not. I did not.
Okay,
No.
well, you just said you wanted $1,500 for your concrete. What? $2,000
Yeah, that-
back from your deposit, right?
What's that?
You want the $2,000 deposit returned, correct?
Correct.
And then you want $1,500 for concrete?
To fix a big piece of concrete that cracked and broke that he with the excavator when he had an excavator on my concrete and was
Okay.
doing the dry.
All right, well, prove your damages.
I got a picture of it. Can I pull it up here or no?
I don't know if you can or not.
Oh yeah. I don't know. I didn't know how to submit it. Submit the picture of the concrete. I got pictures of all the driveway and everything.
Okay. Gentlemen, I think we better have you come in person so we can actually look at the evidence.
Yeah, like I said, I'm not too clear on what to do. I've called the court a couple times on what to do. They didn't really give me too many.
Okay, but we can't tell you how to present your case, Mr. Sweets, because it's your case. We don't know what it is.
Well, it's just pictures. I don't know how to submit the pictures. I thought I'd be able to
All
submit
right,
them now
Jamie.
during the.
January 18th, 10 a.m. That date work for both of you?
Sure.
As far as for me, I don't know, Your Honor. I'm a full-time caregiver at this point. I'm going through a bad time about coming in.
Well, if you can't come in, just let us know as soon as you know it.
Well, I'm pretty much set on it right now. It's just, I have a patient I've been taking care of since 2008, and we just had she's had spinal stenosis. We removed number 2 and 3 C disc, and we just got on December the 3rd, December the 11th, we have a fracture of her left femur. I have her on some pretty heavy meds. She's been bedbound for the last 6 years, and so I really don't have anybody at this point to take care of her.
Well, how are we gonna take care of this then?
I am a caregiver. I'm also her guardian and power of attorney.
No. How are we gonna take care of this trial then if you can't come to court?
Files, well, I was hoping that my statement might be sufficient.
You want me to make a ruling based on your paperwork?
Based on the paperwork and my testimony, I would hope that that would be sufficient.
All right, the problem is Mr. Sweets has some photographs he wants to share with me,
That's fine. He can
So-
show you the photographs.
but you're not gonna be able to see the same photographs if you're not here.
It doesn't matter, sir, what he has. Those photographs that he's about to show you, there were no damages when I left. I always make a inspection of job sites before I leave. I've been doing this 30 years, Your Honor. I've also worked for 34 District Court. I'm well known. I'm not a scam artist, and I just figured time I tell you my testimony that maybe the truth might come a little clearer.
All right, so let's do this. Let's do it January 18th at 10 a.m. If you can be here, Mr. Stevens, be here. If not, Zoom in, and we'll do the best we can.
Okay.
Anything else, gentlemen?
I was hoping to, am I going to be able to give my testimony?
Not today. I'm adjourning this hearing until January 18th at 10 a.m. so Mr. Sweets can provide me whatever visual evidence he says he has.
Oh, okay. And then I'll be able to zoom in?
If you can be here in person, that would be better. If you can't, then just zoom in on the January 18th date.
Thank you, sir.
All right, anything else, gentlemen?
January 18th is in
Thank you very
court
much.
or Zoom?
Live. I just said live so you can present your visual evidence.
Okay,
Understood?
January 18th in court.
You're going to be in court. Mr. Stevens will be either in court or Zoom, depending on his availability with his patient that he's caregiver for.
Gotcha.
Anything else, gentlemen?
No, sir.
Judge, can you speak with Miss Francis regarding the First National Bank versus Westmoreland,
I can.
please?
Miss Francis, what do you got?
Judge, we had an agreement. Sorry, I got stuck in the waiting room for a minute. But I wanted to see if you wanted me to put it on the record so we could have orders filled out and her wage garn could stop.
Yeah, go ahead. I screwed up though, because I told her we were done, because I forgot you were talking to her. So she's gone. Do we need her to do this?
Well, you could, she was gonna withdraw her objections, but you could just deny it. And we can, we were gonna do $200 a month beginning January 20th.
Was there an agreement as to the money that's currently held?
It would go to the plaintiff. I don't think anything's actually being held. I think we've gotten whatever they've garnished, and now she's off work.
All right, so 200 a month is the agreement, and that's going to start when?
January 20th.
Are you going to be really, really nice and put something in paper and send it to me so I can sign it?
Yes, we could.
Thank you. Thank you so much, Miss Francis. If you email that to Sandy, we'll get it executed today and send it out.
Okay, I don't have her email address.
We'll chat it to you. How's that?
Okay, sounds good. Thank you.
All right. Heather, what do you got?
Bank of America versus Turner.
All right, appearances, please.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
Excellent, thank you. Mr. Turner, are you connected?
I'm here, but it doesn't show me in the room.
Okay. We can probably do without your video if you cannot get it connected. All right, so Mr. Turner, you filed objections to a garnishment, correct?
Yes,
And looks like probably a tax return garnishment?
correct.
That's correct.
Okay. And your reason for the objection is that you have an agreement already in place with the law firm for monthly payments of $75 a month, correct?
Correct.
Okay. Anything else you want to add to your objection, sir, before I give counsel a chance to respond?
Well, only thing that I don't have with me now, I contacted an attorney with debt stoppers, so I am filing bankruptcy this week. So I just don't have a case number, but.
Okay. All right. Anything else, Mr. Turner?
No, that'll be it.
All right. Counsel, on behalf of Bank of America, your response.
Yes, Your Honor, I'll just be brief. The payment plan Mr. Turner's on does not stop a non-periodic garnishment. So there is not a valid defense for the objection to garnishment as to the state tax income garnishment. However, obviously, if Mr. Turner does complete his bankruptcy, that would deal with this matter as well. But for purposes of today, I believe the court needs to find the objections invalid.
Agreed. Mr. Turner, you understand that?
Okay, that's fine. I'm filing bankruptcy, so I guess I'll take care of that anyway.
Okay. Good luck.
Judge, would you like me to prepare an order, Judge?
That would be great. Thank you, because I don't have one in the file.
Sounds good. Will do. Thanks. Have a great day.
Thank you.
We have a lot of just individuals that the other parties aren't here, but I'm going to bring in Mark Landoff for Bell Villa versus Crawford. They're the only matching party.
Okay. Appearances for Bellevilla Meadows versus Crawford, please.
Good morning, Your Honor. Mark Land on behalf of the plaintiff.
Mr. Crawford, are you connected?
Yes, I am.
Do you have video?
I can see you fine. Yes, sir.
I can't see you at all.
Okay, hang on.
Looks like
I
we
don't
met
know.
back on December 18th and we adjourned till today's date. Was that for some Sarah paperwork, Mr. Landau?
I don't have any notes in that respect.
I don't know.
Mr. Crawford might have better information.
All right.
Well,
Mr. Crawford, don't sweat it if you can't get your video on. We can probably take care of it just with audio.
Yeah,
Okay.
I can't figure out how to turn it on. I'm sorry.
yeah.
That's all right.
Actually, Your Honor, I
Mr.
apologize.
Crawford,
This is a termination case.
Okay. Why did we adjourn it on December 8th? Nobody knows?
The defendant has a horrible infestation in his apartment, in his mobile home unit. And he was going to give my client access to be able to do an extermination.
Which I did. The exterminator that was provided by the trailer park community has come in here 3 times. The last time he came in here, which was like about 2 months ago or so, he himself said that this is drastically reduced, that it is getting more and more under control. At that time, I told him to tell the office that.
Your Honor, I solicited my client a couple days ago, 2 days ago, for an update to see what the exterminator's perspective was as of now. I haven't received an email back. If Your Honor wouldn't mind passing on the matter, I'll call my client real quick and see where it's at.
No problem at all. Mr. Crawford, just hang where you're at. We'll mute you and we'll be back in touch in a minute.
Okay, I'll be here.
Mr. Pallets is here on, there's Rossonville Woods versus Stumbo, but she did not appear. And that was at 9:15 this morning. I'm sorry, Mr. Morton.
No worries.
Well, this is your motion for reconsideration, correct?
That is correct, Your Honor.
I don't know that I need Ms. Stumbo for that. Do you?
No, Your Honor, I don't believe so. But, we did provide her notice of, we did, send her a copy of it. And I know she did receive the hearing notice, but she's not required to be present for the court to hear and make a ruling.
Okay. I've read what you submitted. I don't know. I don't think I saw anything that I didn't see or hear at the hearing. So is there something new?
Your Honor, I'm sorry, Your Honor. Was it, if I may?
Yeah.
Thank you. Your Honor, we just feel like it's appropriate. The 3 things that we want to have the court make sure that they consider in this is, one, was it, the fact that, was it because, even though this involved, an assault by the tenant, we feel it's necessary that, was it that the proper, was it, preponderance of the evidence is put in place, because was it, we have a concern that, that a higher standard may have been put in place because of the physical altercation that occurred. Additionally, beyond that, Your Honor, was it because of the, was it the court made the decision because of the lack of, was it physical, was it injury and or physical, was it of a threat of physical injury? Was it the court's initial ruling? That's why we wanted to put in front of the court with the definitions as, provided by Black's Law Dictionary. Was it about communicating the intent to inflict harm or loss on another party? Was it or a piece of, or another person's property? Was it? And the actions that we showed in the video, we feel fall within the definition of Black's Law Dictionary. If you look to that, in addition, beyond that, Your Honor, and the court can take judicial notice of this, that the prosecutor themselves has recently initiated a case under case number 21-0882. We have the court take judicial notice of that as that's filed in the 34th District Court. And
What's
an
the charge?
assault and battery.
Exactly. What I saw in the date of the hearing was a battery, an unconsented touching. The testimony from Ms. Stumbo not only was more credible than your witness, but it was also corroborated by what I saw in the video. It was an unconsented touching. What the eviction requires is physical damage or threat of physical damage. I didn't see Ms. Stumbo raise back her hand like she was going to strike anybody. She basically did like a cat pawing a toy when she was saying in her testimony, COVID cooties. That's an unwanted touching. Offensive perhaps, but it doesn't rise to the level of being physical harm or threat of physical harm. I can't believe the legislature intended for people to be evicted for offending someone. If they did want that, then they could have reworded the statute so it says all you have to do is offend the management and they can kick you out. So I've reconsidered. I haven't changed my mind a bit. You can appeal me to the circuit court.
Your Honor, may I ask just one clarification? So the court's ruling is based specifically on, was it the 657-14, which we referenced, which is the threat statute, correct, Your Honor?
I don't have the numbers in front of me, counsel, but what statute is there that says you can evict somebody because they've offended somebody? The statute I looked at that you referenced in your brief, the statute I referenced required either a physical injury, which I think we'll all agree there was no physical injury in this case, or a threat of physical injury. There was no, from the testimony that I believed and from the video action that I viewed, I didn't see any threat of physical injury.
So the actions that we showed in the video, the court's viewing didn't rise to the level of a physical threat then?
Absolutely not.
Okay. Your Honor, if I could just submit, I'd like to propose an order to have a final order entered by the court in this, unless the court would like to issue it themselves. I can present it to the court and the court can look at it.
If you want it on paper, you prepare it and send it in.
Okay, because then at that point, Your Honor, right, my client can then make a determination if they wish to do an appeal or
absolutely.
Depending on the result of this assault and battery, it might be a criminal act and then a lease violation in that respect.
Yeah, circuit court judges need to eat too, so I'm all for appeals.
Okay, Your Honor, the only other matter I would raise is I do have one other case. I'm not sure if it was taken off the court's docket already or not.
Give me the name.
The name is Holiday West versus Darnell Thomas, 215050 LT. We submitted
I scratched that one this morning.
Okay, wonderful. I just wanted to make sure the court got that agreement and it's been
we got
taken
it. We got it. We scratched that this morning.
Thank you, Your Honor.
Happy holidays.
Thank you.
Judge, I just put Mr. Landau and Mr. Crawford in a breakout room. I'm bringing in Mr. Finkelman. He was at 9:30.
Okay.
The other party, the Pons versus Cheatham.
Yep.
And same thing with Mr. Katz. He is Barrington versus Sanders.
Thank you.
You're welcome.
Counsel, your appearance for the Ponds, please.
Good morning, Your Honor. John Finkelman appearing on behalf of the Ponds Gateway Association.
All right, so we don't have Ms. Cheatham. She filed objections, correct? Is that what we're here for today?
That is correct, Your Honor, and it actually was counsel for Ms. Cheatham that filed the objection. We had actually, the garnishment had expired and we went ahead and withdrew it. And I think following the filing of this objection to garnishment, but we've or at least submitted or sent in another garnishment to the court. So I thought that the other side would still appear today regarding the objection of the garnishment, but that appeared to be essentially their main focus, was that the garnishment had not been served in time, which it hadn't been, and hence we withdrew it.
Okay, all right. So today's motion is moot because you withdrew that objection or withdrew that garnishment.
That's correct, Your Honor.
Okay. I think that'll take care of it then.
Thank you, Your Honor.
Thank you. Enjoy your day.
You too, Your Honor.
Mr. Katz, are you connected?
I am, Your Honor.
Good morning. Your
Good
appearance
morning.
for Barrington Romulus Apartments versus Mona Sanders.
Good morning, Your Honor. Sidney Katz, P51471 on behalf of the plaintiff.
And we have not seen Miss Sanders. Why did we adjourn this one, Mr. Katz?
Oh, I believe because they said that they were going to, they're applying for some additional assistance, not through Sarah. And to date, they haven't received it. So at this point, I'm going to request a judgment, Your Honor.
Send it in.
Okay, do you want the amounts?
Yeah, put the terms on record, please.
All right, Your Honor, as of today, there's a balance due of $2,922, which includes costs of $152, requesting a default judgment in that amount, with the writ to be issued after December the 28th, I think it would be. Oh, no, I'm sorry. Today's the 21st, so it would be January 3rd. Is that right? Is that the next date the court's open?
Oh, hell, I don't know.
Yeah, because the 31st would be 10 days, so we're looking at January 3rd.
Yeah, we're here Monday. Yep,
Okay, all right.
that works.
Thank you. I will submit that to the court.
All right.
Thank you, Your Honor.
Holidays.
Same to you. Happy New Year.
Thank you. Sandy, I got advantage 1 versus Mitchell. Mr. Holtzman is the attorney. We had him on an earlier case, but he never mentioned anything on this one. This was a show cause on a creditor's field up here on a creditor's exam, I think.
It says she's connected. She's just not answering, Judge.
She must be on the phone. Mr. Landau, are we ready on Crawford matter?
Yeah, Your Honor.
All right, what do we got?
Your Honor, with the court's permission, we'd like to adjourn this case to sometime in early to mid-January. I did speak with my client. She indicated that the exterminators, she tried to get the exterminators back out over the last couple of weeks to reassess and exterminate again as needed. The exterminators just weren't available. So we want to give that a chance. I did advise Mr. Crawford of good news, which was that in speaking with the manager, she said if the infestation gets under control, Mr. Crawford and his family, they're otherwise good tenants, and she's willing to let them stay. But that extermination needs to get under control. The infestation needs to get under control because there are 2 units on each side of Mr. Crawford that have now become infested, and so that really needs to happen. But as long as it's happening, then I think we're going to be able to reach a resolution that allows him to stay.
Okay, so the next date we've got is January 18 at 9 a.m. That work for everybody?
Works for me.
What time?
What time again?
9 a.m.
Okay.
Okay, that'll be fine.
Thank you, Judge.
What was the date again? I'm
you.
sorry. What was the date
January
again?
18, sir.
Okay, thank you.
Thank you, Judge. Have a happy holiday. Mr. Crawford, have a happy holiday.
You too.
And Sandy, if you're there in the background lurking.
That's my wife.
Oh, thank you. Merry Christmas.
Okay.
Sandy was on a
Sandy, are
phone
you
call,
there?
Judge.
Ah, okay. So do you know anything about either any of these files? Sun Homes versus Green, Advantage versus Mitchell? Heather, you got no information on those?
No, I don't, Judge. I'm sorry.
All right, then I'm gonna walk everything down. What was our last one scheduled? 9:30. So I'm gonna walk all this stuff down to Sandy and find out what she knows about those mystery files.
All right, and I know, Andy, are they almost ready for the arraignments? She must be away
Nobody
also.
talked to us today.
I have two files for, yeah, I have two files for arraignment, but I don't see that any of the police departments have checked in yet.
All right.
Heather, can you hear me?
Sandy, Judge is on his way down.
Okay, I was having trouble with my microphone. I just got it
That's
fixed. So I'm listening to you guys going, hey, I'm here.
Heather, was it Sandy you needed and not me?
What was that?
I was asking Heather if it was you that she needed and not me.
I think she needs you. She doesn't need me anymore.
Okay.
Okay, bye.
Bye.
Sorry, Andy, I was on the phone. I was just instructing the judge that we had videos left or video arraignments.
Gotcha. I'll go ahead and have them hop on.
Yep, thanks.
Thanks. Good morning, Romulus. Good morning, Mr. Bitar.
Good
Morning,
morning.
Andy.
And it'll be just a moment. I'll let the judge know that we're ready.
All right.
Judge, we have
Good morning,
Romulus.
Mr. Bitar.
Morning, Your Honor.
Good morning. Mr. Bitar, your appearance for Susan McDougal.
Daniel Batar, on behalf of Ms. McDougal, Your Honor, I've gone over the charges. Waive a formal reading, stand mute, please.
Thank you. We will enter a not guilty plea. All right, Ms. McDougal, I need to confirm your date of birth. We've got paperwork that's got the 23rd of September, and we've got paperwork that says 22nd of September.
23rd.
Thank you. And address is 28333 Bonanza, correct?
Yes.
Phone number 213-0136.
Yes.
Thank you. All right, we're looking at a pretrial date for Wednesday, the 29th. That'll be my courtroom. And we're gonna do it at 10:15. And Mr. Bitar, Police Department's asking for a personal bond with no contact with Erica. Anything to add on that?
Well, Judge, I don't know if the police have any issue with a non-assaultive contact provision instead. That is the home in which she, Ms. McDougal, resides with the 16-year-old granddaughter.
Erica's the 16-year-old granddaughter, I take it?
That's correct, Judge.
All right.
Your Honor, we have no issue amending the no contact to a non-assaultive contact order.
Thank you, officer.
All right, Ms. McDougal, I'm gonna put you on a personal bond, a couple conditions. Stay out of trouble is one, cooperate with Mr. Bitar so that we can have a meaningful court date on December 29th is another. And the last one is not to harm, harass, or confront Erica. So no further problems between the two of you. If there are problems that I determine you're at fault, that violates bond. Understood?
Yes.
Can you raise your right hand for me, ma'am?
Yes.
Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you violate bond?
Yes. I do.
Do you have any questions for Mr. Bitar?
No.
You're all set.
Ms. McDougal, you'll have to appear on Zoom for that court hearing on the 29th, okay?
Okay.
All right.
I will.
All right, good luck.
Thank you.
You're welcome.
Judge Oakley, what's the case number?
Oh, I'm sorry. I always forget them. Case number is 21-0941.
I have it. Thank you so much.
All right. Be safe.
Thank you.
Merry Christmas.
Thank you. So I can go.
And Heather, looks like we're waiting for Huron.
We are waiting for Huron. I did call them and let them know, so they should be on the way.
Thank you. Mr. Bitar, you've already talked to Mr. Green, correct?
Yep, I sure have, Judge.
Andy, is this the guy that we've had so many problems with?
Yes, I did include an ROA printout for his felony case that was recently sent to Third Circuit as an FYI. It's pending.
Yeah.
And I believe I put the next date in there as a February date.
Yeah, yeah.
And Andy, you asked for an address for him.
Correct,
And
because the Versailles address is he can't return there.
The only address I have is the one that's on the ROA then, or the only one he was able to give me is the 9882 Monroe Street in Taylor.
Okay, so we'll change the new case to that one then, because the new case still had the Versailles address on there.
Oh, okay.
Dan, is this guy getting any help anywhere?
I don't think so, Judge. He keeps going back because his wife and daughter live at that address, but I don't think he has anywhere else as a stable residence.
Right. I think we've got problems with this guy going back a decade, if it's the guy I'm thinking of.
The only cases I see, well, there is a case from 2012 for interfere with police that's closed.
It's not the guy I'm thinking about then, I don't think, because the guy I'm thinking about, it's like constant trespasses.
No, the only two trespassing charges that he has are the two that are in front of you.
Thank you.
Mm-hmm.
You might be thinking of Mr. Lyons, Judge.
Is that a Huron guy?
Yes. And he has multiple domestics, and he keeps going back home. I don't know if that is the one, but it is a Huron person.
Yeah, it might be. Good morning, Huron Township. Mr. Bitar, your appearance for Mr. Green.
Daniel Bitar on behalf of Randy Green, Your Honor. As to the arraignment, we'll waive a form reading. Stand mute, please.
All right, I'll enter not guilty plea on both these files. We've got two different
Is it muted?
dates, one for December 20, 21, and one for June 4, 21. Each one, we're going to schedule a pretrial
Yeah, like
for
the
January
numbers.
13
The number,
at
like the
9,
number.
10. All right, Mr. Green, you got to quit talking while I'm.
Yes, sir, sorry.
That's all right. You're just talking on top of me. January 13, 2022 at 9:10 will be the pretrial. Those are going to be in courtroom 3. And looks like the bond rec is for personal bond. I'm assuming that's okay with Mr. Bitar and Mr. Green.
Yes, sir.
Yes, sir.
Raise your right hand, Mr. Green. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on each of these two files for a total of $2,000 if you are not here for your court date?
Yes, Your Honor. I swear.
Stay out of trouble, cooperate with Mr. Bitar so we can have a meaningful pretrial. Understood?
Yes, sir.
Officer, case numbers 21 HR 13295, and 21 HR 06238. Anything else, Mr. Bitar?
What was that last one?
HR 06238.
Thank you, sir.
Nothing on behalf of the defense, Your Honor. Thank you.
All right. Happy holidays, fellas.
You as well,
You too.
Judge.
Thanks, Your Honor.
Oh, I was gonna tell him, make sure he appears on Zoom, but I guess he's gone already. All right, everyone, take care. Good to see you. Merry Christmas and Happy New Year if I don't see you before then.
Same to you, Dan. I don't think we got anything else coming in, but if something comes in late or last minute, we'll call you.
Thank you.